the mind of either of the three defendants in this case. There's been a lot of suggestion from their questioning, or so they're willing to call expert witnesses to talk about what a reasonable person would believe under the circumstances. It's not proper under the law. It's pretty clear that the only times that a person could put on evidence such that is or state of mind evidence is with an insanity defense or with a defense of a justification on a domestic violence victim situation under 3836. So we just want to be sure that there are no references to that in opening statement, or any of that evidence is elicited through a expert or witness that the defense intends to call, unless they approach the bench and we have a hearing outside the presence to see if that's what's going to happen.
Judge, in response to that, I would agree that the experts can't say what the particular defendants were thinking at the time, but I believe that they are able to opine upon what a reasonably trained officer in a similar situation would reasonably believe, and whether the reasonable belief would be consistent with certain facts. So I don't think we should be precluded from asking questions in that format.
And considering that this is not a federal trial, this is a state trial guided by state laws, the element for the jury to consider is the ordinary and prudent person standard. It has nothing to do with evidence about what a reasonable police officer would do based on what a purported expert would have to say about that. And it's already been decided by the court that the state can't do that. So what's good for the goose is good for the gander. The defense can't do it either.
I don't think it's been decided by the court that the state can't do that. I think that they didn't have anybody willing to say that. But as far as, I mean, Mr. Cifuentes is right. There's an objective, but there's also a subjective standard that goes under that, because you have to, and the court's going to instruct the jury that they have to put themselves into the position of the officer, as viewed from their standpoint, as viewed from, and you know, by necessity, they have to view it from the standpoint of men acting as police officers, doing what they were doing at the time. So it's that subjective part of it that our experts, who are all also police officers, former police officers, and have been trained and trained, all of those things they can talk about how training, how perceptions, how those perceptions all work together in order to be able to form a reasonable belief for an officer. And as Mr. Cifuentes said, we're not offering any testimony as to like what these individuals were thinking at the time, and that's what the state is talking about in their motion, which I agree with that. Like we don't, as far as their motion is covering what these individual officers are thinking at the time, there's not an expert that can testify to that. But they can testify as to what somebody in that situation would be experiencing, would be thinking, how they would be reacting, and whether or not that was reasonable. And that is what we're going to offer the testimony on. So rather than have to approach, we just like the court to make a ruling that would be appropriate, so we don't have to keep coming up every time we want to ask those questions.
And Your Honor, we've asked to do that. We've asked to do that. And then if he's saying that they would be allowed to do that, in the same way we should be able to do that. But the court has, by its earlier rulings, said we can't mention policies and training and how they affect the subjective reasons of an officer or these officers at the scene. So I don't understand why they're arguing that they can do it when we cannot.
Well,
I don't understand.
Yes, Your Honor, but that's not what the court restricted. We did ask to restrict on like policies, SAPD policies. We're not going to ask our experts those things. We talked about tactics, and I believe the court restricted what they were trying to get was like tactical officers to talk about those tactics. We're not going to be asking about tactics. We're going to be asking about when somebody is at a place and a woman is coming at them with a hammer in this situation. What is training? Because training is important, and they have asked about training. Training is important because you were trained to, for instance, you were trained to meet deadly force with deadly force. You were trained to draw a firearm when confronted with a weapon. And we've been talking about that the entire trial. And so things like that, as part of their training, is definitely relevant. And these experts who train police officers to do these things would have the requisite expertise to be able to talk about those things.
Then we won't rest. If we're gonna be able to do that as well, Your Honor, if you're gonna lift that prohibition on us being able to talk about what a reasonable police officer would do based on a person's years of training and expertise and experience in the field, then we wish to put on more witnesses, because we have been prohibited from doing that. Your order explicitly said we cannot talk about training, and we can't talk about policies. And those are exactly the kinds of things that would inform these experts' opinions on what a ordinary and prudent police officer would be doing from their standpoint.
I think the distinction, Judge, is use of force, reasonable use of force, and whether it's imminent versus policies. And it came out, even though it was asked, it still came out that policy is not the penal code. So I'm not sure what the confusion on the distinction is. I mean, you had Detective Soto arguing that I just think they could have done things differently. Well, we can have an expert to say they should have done things differently under those circumstances that they were dealing with. So that's a reasonable use of force. That's something the jury needs to hear evidence on. Now, the individual SAPD policy was what you ruled on. Whether the policy general manual 501 or 502 says this, well, that's irrelevant when it comes to the penal code. But when it comes to reasonable use of force, I don't believe that's what the court's instruction was. And as a matter of fact, our detective made a comment on it, so we should be able to rebut that.
Let me ask the state, so what did you expect, or what would you expect your witnesses to testify to specifically?
We would expect them to testify from their years of training and experience and their training of police officers in the field and handling emergency situations, barricaded situations of individuals, that they're trained to respond in a certain way, that their mindset is considered as far as preserving life, protecting life in these situations, and exploring other alternatives before jumping into a situation where an officer might get hurt or a victim might get hurt. The person can, the other people we have other experts that can talk about, they trained these officers specifically on how to handle these kinds of situations. And if they didn't handle them the way that they had been trained in less than a year before, it suggests that an officer is acting, if they're acting against their training and against their policy, they're acting unreasonably in their response.
Well, that was, I'm sorry, David, if you're not finished, go ahead.
And all the things that they purported to talk about as far as how officers respond and are taught to use force in certain situations and to de-escalate in other situations are the same things that this expert can talk about without talking about what these particular officers believe.
I think the slippery slope is what he mentioned is the policy, Judge, versus reasonable force, and whether it was excessive or not, or that circumstance. I mean, the SAPD policy is irrelevant when it comes to reasonableness under the penal code. So if that's the distinction and that's the confusion, so I don't think that our hands should be tied to show that under these circumstances that this behavior was reasonable. I mean, again, forget policy. We're not going to mention SAPD policy because we don't care about it at this point. But when we're talking about the penal code and what this jury has to deliberate on, I believe we should have an opportunity to offer evidence to show that they were reasonable.
And Your Honor, counsel, I realize it's the only argument he can make, and he's got to be an advocate, but it totally misses the point of what Chapter 9 says. Their witness, Detective Soto, said the only reason the officers were not reasonable is they failed to choose an alternative aside from the one they chose, and their plan was wrong. But he did not negate that Melissa Perez's threat was immediate. He did not negate that her threat to use the hammer could cause serious bodily injury or death. He did not negate that the defendants could reasonably believe that force was immediately necessary to stop Melissa Perez's unlawful use of force. So, again, we argued previously that bad tactics did not cause her, Melissa Melissa Perez to engage in the unlawful conduct. And under Texas Penal Code 6.04, what they're attempting to do is to suggest that they provoke the difficulty by their bad choices. And you've already ruled on this, and federal courts have already said there's no such thing as officer-created danger. In essence, officer-created danger embraces concepts in the Texas Penal Code, which is, number one, that officer-created danger does not trigger the causation necessary in 6.04, that their bad tactics was sufficient in itself to cause her to engage in bad behavior, illegal behavior, violent behavior, behavior that threatened their lives, and that it threatened their lives in a way that required an immediate response. Their suggestion that bad tactics caused those things is totally untrue, can't be proven, and not even their witnesses testified that it caused her to engage in violent behavior. In addition, 38.03B says that you don't have the right to resist an arrest, whether it's lawful or unlawful. So they're trying to get through the back door issues that this court has already ruled upon and precluded them from introducing. So their suggestion that what we're trying to do is improper is misleading, because they simply can't say that bad tactics is the cause of the behavior, or that they provoked the difficulty, or that somehow or another their bad tactics gave her a right to resist an arrest. So we would ask that their motion in limine be denied, to the extent that that's what they're suggesting, that they want to get into bad tactics.
All right, so let me do this. So let me, as it relates to the state's motion in limine regarding expert testimony, I'll grant the state's motion. As it relates to the defense experts and testifying, what I'll do is I will recognize and I'll allow that testimony, and then subsequent to that, state, if you want to call it any witnesses to rebut, then you could do that.
Okay, let me see if I'm clear, right? The
Yeah.
motion limine is granted, they can't talk about it in an opening statement. Any expert that they call that purport to do that will have a hearing outside the presence of the jury to
Yes.
see if they're within the bounds,
Yes.
right? And if that's the case, what they testify to, we are permitted in rebuttal to talk about those things, whether it be training or policy or whatever it is necessary to rebut what they say.
Correct.
Okay, understood.
All right, anything else?
No, Your Honor.
And with that understanding, are they going to arrest or not?
We are. We will rest on that basis.
And if we could take a short recess, I'd be ready to argue immediately afterwards on the instructed verdict.
Okay,
Maybe take a break?
yes, take a short break.
And Judge, I think Mr. Lennon said, well, if he granted it, then he would call them witnesses or whatever. I guess the idea is we can argue it and the court can reserve its decision,
Yes.
just so we can save time.
proceed today. Going to give you a lunch break. And I know there was a question with one or more of you about leaving at a certain time today, so we'll leave between 4 and 4:30 at the latest. We'll try to aim closer to 4, depending on where we're at. All right, where we last left off, State, we were in your case in chief. You may proceed.
Stay with rest on this case in chief, Your Honor.
All right, members of the jury, what that means is that we're going to have you go back into the jury room. We're going to take up the matter outside your presence. I'll bring you back when we're ready.
All right, for the jury.
May be seated.
All right. Defense?
Your Honor, I would like to proceed first on a motion for instructed verdict. I must confess to the court that last night I had 4 editors because unfortunately I was unable to blend it into one document. If I may read it into the record, I'd like to proceed, and if I may be seated while doing so.
Yes.
For the case stub 2023 CR 11510A, B, and C, the state of Texas versus Alfred Flores, Eleazar Alejandro, and Nathaniel Villalobos in the District Court 379th Judicial District, by the undersigned Ben Cifuentes, to the Honorable Court, to the Honorable Judge of said court. Now comes Alfred Flores, Eleazar Alejandro, and Nathaniel Villalobos, defendants in the above styled and numbered cause, and moves this court to order an instructed verdict of not guilty and for good cause shows the following. The state has failed to prove the essential elements of the offense alleged against the defendants, including disproving the defense of justification. At this time, I would request the court to, for the limited purpose of this hearing, 71, which we previously have asked the court to take judicial notice of, and that is case number 5:23 CB 00847-FB. Judge Ben Perod's report and recommendations of the United States Magistrate Judge. We asked, it's a 21-page document which we previously provided to the court. We ask that the court take judicial notice of this for this purpose of this hearing. We believe it's relevant and admissible for the judge determination in this case outside the presence of the jury, because as we will set forth in detail, the document 71 details why the actions of the defendant was reasonable under the circumstances. The actions that are alleged as the basis of the indictment, that the threat by Melissa Perez was the threat of serious bodily injury or death with a deadly weapon, namely a hammer, that the officers believed that it was immediately necessary to defend themselves against the unlawful use of force was necessary and reasonable, and they had no duty to retreat, and that there were exigent circumstances to make the entry. All of these findings negate any claim by the state that the officer's conduct was not justified. Moreover, the state produced no evidence to refute the findings of the magistrate judge. Since they produced no evidence to refute the findings of the magistrate judge, there's no evidence to disprove the justification defense that the defendants have advanced. I will return to that document, but I will continue with my assertions that the defendants were peace officers in the lawful discharge of their duties as San Antonio police officers attempting to arrest Melissa Perez on June 23rd, 2023, when Melissa Perez resisted a lawful arrest after she committed the following felony offenses of criminal mischief of a fire alarm and 3 aggravated assaults against a peace officer. when the defendants began implementing their lawful arrest of Melissa Perez at approximately 02:02:04 a.m. on June 23rd, 2023, Melissa Perez ran to retrieve a hammer and ran towards the patio window of her apartment living room while raising and swinging the hammer tomahawk style. The undisputed video evidence from 4 or more body cameras confirmed this deadly attack, and witnesses testified this charge and assault could be reasonably perceived as an attack with a deadly weapon. I wish to point out that the magistrate judge report considered the pleadings in the civil case, and the magistrate judge wrote, however, the court may also consider documents attached to a defendant's motion to dismiss when they are referenced in the complaint and are central to the plaintiff's complaint. And then the magistrate judge went on to explain in a footnote number 2, in their response to the officer-defendant motions, plaintiffs also confirmed they do not object to the courts considering the body-worn camera footage when evaluating the merits of the motion, and aver that the motion should be decided on the record at hand, including the body-worn camera footage. When this court reads the document 70, this court will realize that Magistrate Judge Bimperod reviewed the same body-worn camera videos which were introduced in this case, including those of the defendants. Thus, when we assert that the undisputed video evidence from 4 or more body cameras confirmed the deadly attack, that was also confirmed by Magistrate Judge Bimperod. And estimated the placement and size of a window screen that was knocked down to the patio floor by Melissa Perez's hammer swing at 1:40:50, and this was on Officer Ramos and Officer Salinas' body-worn camera, and at 02:02:07, which was on various body-worn cameras and stills, in particular Edwin Rivera's, agreed that one corner of the screen was more than 1 foot from the outer patio rail. Detective Soto agreed that the specific corner identified as noted previously by the CSI and in this motion was where Alfred Flores' feet were located when the hammer struck the patio window. All witnesses either agreed or did not dispute that when Melissa Perez struck the patio window at 02:02:07, the hammer was less than 5 feet away from the back of Alfred Flores' head. In the undisputed testimony by various detectives and in the videos, all the witnesses testified that at the moment that Alfred Flores was negotiating the patio rail, mounting the patio rail as if he was mounting a horse and turning counterclockwise, that he lacked the ability to see Melissa Perez's unlawful deadly attack with the hammer. In essence, he was defenseless at that moment in time. Being defenseless, he lacked the ability to perceive the danger and dodge or avoid being hit with the hammer. All witnesses either agreed or did not refute that the hammer swing was in a trajectory in line with the back of Alfred Flores' head. This was confirmed by at least 3 or more body-worn cameras, and the trajectory of glass that was ejected toward the back of Alfred Flores' head as a result of Melissa Perez's hammer blow was in line with the swing, the contact, and the direction to the back of Alfred Flores' head. Eleazar Alejandro gave a statement to Ronald Soto explaining he believed that Melissa Perez was throwing the hammer towards Alfred Flores' head, and all witnesses confirmed that at this moment in time, Alfred Flores was defenseless. This belief by Eleazar Alejandro, as set forth in the statement, was not refuted by any witness. Eleazar fired 5 shots in less than 2 seconds to stop Melissa Perez's deadly assault. There's no evidence that any of these 5 shots hit Melissa Perez. Now, afterwards, Melissa Perez ran back to her living room couch between 02:02:07 and 02:02:09. She then got up from the couch, went to the open hallway between her kitchen and living room, and stood facing the patio door to the right field of view from the body camera. At 02:02:10, she was standing in the hallway with the hammer still in her hand. She looked directly at Alfred Flores for a second, then began charging rapidly, aggressively towards the patio door, which was a French-styled window door where both Nathaniel Villalobos and Alfred Flores stood. A reasonable officer in Eleazar Alejandro's situation at 2:02:12 would have believed that after the first charge and first volley of shots, Melissa Perez would have surrendered by throwing down her hammer, giving up her deadly weapon, and showing a willingness to submit to an arrest. Instead, having been fired upon, she again began a second deadly attack, showing a determination to kill or to be killed resisting her arrest. Her intent to resist arrest is confirmed by the fact that she stated on body camera several times, "Shoot me," and that was during the first time she swung the hammer twice at Jonathan Salinas. Then several times she informed officers that she was not going to go to jail again, that she's already been to jail 3 times and she's not going to do another 45 days. Additionally, in the second attack at 1:55 against Nathaniel Villalobos, afterwards she stated to Officer Villalobos, I believe she used the F word, and then said, "Fight me." It's noteworthy that during both of these assaults against Jonathan Salinas and Nathaniel Villalobos, approximately 11 minutes apart, several officers drew down and pointed their weapons at Melissa Perez for a lengthy period of time, knowing that the officers were threatening deadly force against her based upon her unlawful use of a deadly weapon, namely a hammer. Continuing back to 02:02:07 and the second charge, Melissa Perez charged towards the patio door a second time, and only when she was nearly against the wall in line with the patio window and patio door did Alfred Flores fire at 02:02:13, when Melissa Perez was upon the door, had the ability to exit and attack the officers. As noted in Judge Bemperod's opinion, it would be unreasonable for the officers to have retreated at that moment in time, because even Judge Bemperod noted from the body-worn cameras that both Sergeant Flores and Nathaniel Villalobos had difficulty negotiating hopping over the patio railing, and Judge Bemperod determined that retreating would not have been practical, even though the officers did not have the duty to retreat, and that had they retreated, Melissa Perez could have opened the door and attacked them, and they would have been vulnerable the way Alfred Flores was vulnerable by being hit in the back of the head. After Alfred Flores fired 3 shots between 02:02:13 and 02:02:15, Nathaniel Villalobos fired 3 shots into the wall where he reasonably believed Melissa Perez to be standing. Nathaniel Villalobos reasonably believed that while Melissa Perez was standing in this 2-foot wide wall, that she could have either have moved, and from the perspective of the officer, she could have either moved to the left and thrown the hammer through the open window at Officer Eleazar and Travis Thompson and others nearby, or have opened the door or swung the hammer through the windows and struck either Nathaniel Villalobos or Alfred Flores. After Nathaniel Villalobos fired, officers yelled out that Melissa Perez was down. Noteworthy, all the officers ceased firing when the danger was no longer present. Nathaniel Villalobos belied any intention to cause the death of Melissa Perez when he kicked in the door to make entry to be able to render first aid. He found Melissa Perez inside, and the video camera shows that she was still holding the hammer in her hand, and that he immediately grabbed the hammer, threw it to the side against the wall to the right of the patio door, and then immediately began administering first aid in an attempt to prevent Melissa Perez's demise. Officer Eleazar Alejandro later jumped the railing, entered the apartment, and attempted to assist in life-saving efforts before Eleazar Alejandro was ordered to leave the apartment. Detective Soto admitted in testimony that this conduct shows and belies any intent to cause the death of Melissa Perez, and these actions show that they were trying to save her life. And the course of conduct in this 8 seconds of time was immediately necessary to effect a lawful arrest and to prevent Melissa Perez's unlawful use of deadly force against Sergeant Alfred Flores and Nathaniel Villalobos. The state has suggested that the defendants acted as parties to commit the offense. However, as this court knows, mere presence alone is insufficient to make one a party to an offense. The state must prove that the parties acted with the intent to commit the offense. There's no evidence there was a prior agreement between the parties to commit the offense, and there's no evidence that one or more of the defendants encouraged, aided, or abetted the others because there was simply no time to take action. The fact is that each individual defendant responded independently because of the threat of unlawful deadly force that they saw Melissa Perez engage in, and they acted independently to protect themselves and third persons and to effect an arrest. Thus, there can be no law of parties in this case. And as stated before, Detective Soto testified that he did not believe the defendants had the intent to commit murder, else they would not have attempted the life-saving measures. The state sought through various theories as to why it believed defendants committed murder, but in the course of nearly a 3-week trial, this court has seen how those theories have changed as the court refused to permit unsound legal theories to be unveiled. Such legal theories were inconsistent with the state's conduct in violation of Texas Code of Criminal Procedure, Article 20A.256, and also the Code of Respect 3.09 of the Texas Code of Professional Responsibility. Specifically, the state sought to suggest that Officer J. Salinas was trespassing or committing a burglary when at 1:40, 50 or so, he attempted to enter Unit 3102, and that he was told by the state that had Perez clocked him with a hammer and hit him in the head, and had he died, she would not have been charged with any crime because he was unlawfully entering the residence. When that theory was not allowed, the state then changed its strategy and testimony. What's noteworthy is that the state refused to grant several witnesses immunity, witnesses whom they did not call. They did not grant immunity to Travis Thompson, Vince Gomez, or Maria Salinas, and they did not call those witnesses. Noteworthy, each of those witnesses gave written statements which could not be introduced because they were hearsay, and thus they thwarted the defendant's constitutional right of confrontation and compulsory process. Now, then the state again shifted its theory that the defendants needed a warrant. This theory was again precluded by the court, and also Judge Bemperod, his opinion clearly delineates that there were exigent circumstances to enter. The exigent circumstances to enter were that Eleazar Alejandro had the need to enter, or the officers had the need to enter because the homeless individual, invalid, Santos de la Rosa, could not be left alone with a woman who was psychotic, crazy, aggressive, a drug addict, and so forth, and it was necessary to protect them. Even the fire lieutenant and Officer Ramos agreed that they would not leave a loved one alone in Santos de la Rosa's situation with Melissa Perez. After the court refused to permit the state to advance the theory that the officers needed a warrant, the state then shifted to that the officers provoked the difficulty by seeking to arrest Melissa Perez. The court once again refused to permit the state to present this theory. This theory is unsound, as we have pointed out in the trial. This theory is insufficient to trigger application of Texas Penal Code Section 6.04. That is, that the officer's misconduct has to be sufficient to cause a particular result. And what, in essence, the state was arguing was that the defense caused Melissa Perez to engage in the deadly attack. Clearly, their conduct was insufficient to that there's no such thing as officer-created danger. After all of the state's theories were precluded, the state was left only with the opinion of a botched investigation from Detective Soto, who conducted an incomplete investigation. He was inexperienced and was not truthful in his arrest warrant. He was not truthful in his prosecution guide, and he was not truthful in his testimony. For example, Detective Soto, in his affidavit for arrest, falsely stated he reviewed all the available digital evidence. This was not true because he admitted that 15 officers uploaded their body-worn cameras by 5 a.m. on June 23, 2023, and a review of the audit trails in Defense Exhibit 102 shows that, in fact, all 15 officers' body-worn cameras were uploaded on or before 5 a.m. on June 23, 2023. If all the cameras, the footage had been uploaded, then the footage should have been available for Detective Soto's review. When Detective Soto was confronted with his user audit trail, showed that he only reviewed Eleazar's body-worn camera for a few minutes, he changed his testimony. The custodian of records for the audit trails testified that if one does not document their review of activity, the failure to document means that the activity did not happen. Detective Soto had difficulty accepting this until he was met with receipts proving that this is so. The first set of receipts proving that the failure to document means that it didn't happen was his own prosecution guide. His own prosecution guide showed that he only detailed 4 body cameras in detail. And he had to admit that his ability to detail those 4 body cameras took approximately 4 months. He would not admit that he had most of his time to do that, but eventually admitted that he probably had about 180 hours or more to review those body cameras. His audit trails also proved that he did not review in detail those body-worn cameras. When confronted with this, he suggested that he reviewed them with his team of detectives, and I believe that ultimately he said he had a team of 8 detectives. If that's incorrect, I apologize to the court. But he admitted that he had help from other, he suggested he had help from other detectives. In fact, none of those detectives who assisted came forward to corroborate his version of events. In fact, the one witness that testified, the detective that testified was Detective Deanna Plott, and she admitted that she did not consult much with Detective Soto. In fact, that she took a limited statement based upon her interview with only the witness and did not discuss details with Detective Soto as he would suggest. Then, when he was confronted with another lack of receipts, he decided that he was going to testify that he did take handwritten notes. When confronted with the fact that we, the defense, wanted copies of those notes, he stated that he provided them to the state. In the course of the trial, we asked that those notes be turned over to the defense. The state seemed to be eager to turn over handwritten notes. When we reviewed those handwritten notes with Detective Soto, he had to admit that none of those notes related to, of the 7 pages of notes, related to body-worn cameras. When he admitted that none of the notes that were turned over by the prosecution related to body-worn cameras, he admitted that he did not review all of the body-worn cameras from beginning to end. And he admitted that he did not look in detail at 10 of the body-worn cameras. Thus, essentially what he has done is admit that he was untruthful, that he conducted a sloppy, incomplete investigation. So he only confessed to the truth after his false testimony became manifest. Given that his false testimony was revealed through cross-examination, he should have no credibility whatsoever. Additionally, as part of the receipts showing that he did not have the ability to look at all the body cameras, he had to admit that he interviewed the Melissa Perez family sometime between 12:10 and 1 o'clock p.m. And he did not start drafting the search warrant until after that interview. With respect to the Melissa Perez interview, he admitted at least 10 or 15 different facts that related to Melissa Perez's state of mind of being aggressive, and that he did not include any of that information in the warrant, did not obtain any of that information prior to the arrest warrants. When he was questioned about his affidavit, he admitted at least 10 or 15 critical facts that he omitted from his arrest warrant affidavit that would go to the calculus involved in the totality of circumstances in weighing whether the conduct by the defendants was justified. By admitting his omissions, he explicitly admitted that either he failed to watch 10 videos to obtain the arrest warrant, or that his omissions were intentional and material. Either conclusion would be fatal to his credibility as a witness, and any claim of unreasonableness coming from him would lack any credibility whatsoever, and would necessarily mean that the state failed to meet its burden of negating justification beyond a reasonable doubt. Now, in essence, the state's case rests on the shoulders of one man, Detective Soto, and as we have pointed out, that proof has evaporated. The law is clear and unforgiving. Once justification is raised, the state must disprove beyond every reasonable doubt the justification, and that case on point is Saxon versus State, 804 Southwest 2nd, 910 at 914. It's the Texas Criminal Opinion dated 1991. This is not a burden the state can waive with speculation, assumptions, or a detective's personal opinions about what officers should have done. The question is singular and precise. At the moment deadly force was used, was Officer Alejandro's belief, and also those of his fellow co-defendants, was it immediately necessary to protect himself and another person from Melissa Perez's use or attempted use of unlawful deadly force? And this is set forth in Texas Penal Code, section 932A. In response to that question, the state has offered absolutely zero evidence that the defendant's conduct was unjustified. The legal standard is not some evidence, but legally sufficient evidence. The court knows the standard is not whether some evidence exists, it is whether it's legally sufficient that would allow a rational juror to find beyond every reasonable doubt that Officer Alejandro and his co-defendants were not justified under Penal Code section 932. A mere scintilla of evidence is insufficient to avoid a directed verdict. The evidence must be legally sufficient to support a rational finding against the justification defense. The threshold question is whether, viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the offense and rejected the justification defense beyond a reasonable doubt. Again, we cite Saxton 804 Southwest 2nd at 914. Clearly, the answer to this question is no. As previously pointed out, Detective Soto admitted that he did not watch all of the videos. He said, "I did not watch all of them, no sir. I just didn't watch all of them start to finish, that's it." And the affidavit for arrest warrant says, "After review of available digital evidence." Well, that's not true. That shows that he intentionally falsified his affidavit. What's noteworthy is that he suggested that he did this on independent impulse, on his own initiative, that he rushed the warrant for no reason, that his command staff did not put any pressure on him. Yet, at the same time, he is a brand new investigator in the office of the officer-involved shooting team, and none of his team members assisted him in any way. None of his team members said, "Hey, slow down," not even his sergeant, not his lieutenant, not his captain. Additionally, Detective Soto admitted he had no evidence of who shot Melissa Perez. Yet he charged 3 officers with murder when he knew that it was not possible for 3 officers to have fired and hit Melissa Perez. And in fact, he agreed, and the medical examiner confirmed, that it's unknown whether 1 or 2 gunshots came from 1 or 2 different shooters. Thus, Officer Soto and the medical examiner's office and those who testified from the medical examiner's forensic crime lab could not establish beyond a reasonable doubt the cause of Melissa Perez's death. And additionally, when cross-examined, Soto would constantly say, "It was my opinion, it was my assumption." He finally had to admit that his assumption is not a fact, and he had admitted that his opinion doesn't matter when it comes to the critical issue. The defense asked him, "Detective Soto's opinion, right, doesn't trump the law. Do you agree with that?" And he said yes. The defense asked, "You would agree with me that nothing in Chapter 9 says that if you don't make the perfect tactical choice, you lose your justification?" The defense asked, "Have you read Chapter 9 of the Texas Penal Code?" Soto said, "Yes, I have before, yes, sir." But Soto's entire theory rests on his opinion that the officer should have done something different. His opinion does not address whether the threat was real or apparent or reasonable at the time the officers fired between 2:02:07 and 2:02:15. He only used his opinion that there was some driving force that required officers to enter. It's clear that when he was describing certain things such as a driving force, barricade, retreat, tactical retreat, that none of those terms were used in his prosecution guide. What this court can reasonably deduce is that some political pressure came down and caused him to use such terminology when he did not use that in either his affidavit or his arrest warrant. Additionally, Texas Penal Code Section 9.32 contains no perfect tactics requirement. There's no Monday morning quarterbacking exception. And the only provision in Chapter 932 that applies is was whether deadly force was justified because the officer acted as a reasonable officer would have done under the circumstances of the defendant. And even when Detective Soto was offering his opinion about what the driving force was, he testified, I just don't understand what the driving force was to get in that apartment right then.
I'm sorry, repeat that?
To get in that apartment right then. The defense said, but Detective Soto's opinion, right, doesn't trump the law. Do you agree with me? He said, yes. The defense asked, officers have every right, just like everybody else, to defend themselves. You understand? Soto said, yes, sir, I agree. At this time, Your Honor, I would ask that the court permit Mr. Del Prado at the appropriate time to complete the argument, and if he wishes to do so at this time or wait until the other attorneys address the court, I will defer to Mr. Del Prado.
Your Honor, I think Ben's pretty well covered it. Just a couple of things that I want to go over and touch on. I think it's abundantly clear to the court, hopefully it's abundantly clear to the court, as the gatekeeper in determining whether you allow this case to get to a jury. We all watch these videos, and I think it's fair to say that this jury has probably watched these videos certainly more than the state's lead detective, who was at a loss for the names of the personnel or when and where things occurred. When the videos are slowed down, it's apparent, and not even getting into Ms. Perez's first two deadly attacks on first Officer Salinas and then Officer Villalobos, but when Sergeant Flores and Villalobos were on the patio, her first deadly charge for that incident, and it slowed down, everyone, even the detective agreed, yes, the officers were met with deadly force and they are entitled to use deadly force at that moment, because every single case, every single law says that is the moment of truth. At that moment, was it immediately necessary to meet? Did they have a reasonable belief as to that? And not even this detective could dispute that. So when it slowed down, that was clear. And then Mr. Nesbitt put on a brilliant demonstration showing the court and this detective, who once again was shown to either have a faulty memory or just to be making things up because he hadn't watched these videos closely enough. If he would have slowed them down, or if at the grand jury presentation it had been slowed down for the grand jurors. We're here like some 860 days after this incident, Judge, and apparently no one from the state or the San Antonio Police Department ever slowed these videos down to see, because even the detective agreed, yes, the charge at the door, the sergeant waited until the last possible moment, and he acted in protection of himself and Officer Villalobos, which they're entitled to do under the law to protect themselves from deadly force. They're entitled to meet deadly force. Not just police officers, but any citizen of the state of Texas. So I think that was clear. Just watching the videos, we can say these men acted legally, they acted appropriately, they acted reasonably. And then, as far as the charge of murder goes, and the jury saw and the court saw, these officers acted immediately to render medical aid to save this woman's life. And their own witness said yes. He said they didn't intend to kill her. They've undercut their own charge for murder, and their other theory of murder there's been absolutely zero evidence of. So their only witness says, yes, these men did not intend to kill her. That undercuts their entire prosecution. And I know Ben has covered the ineptitude of this detective and just the arrogance of an unprecedented murder prosecution. We have never in this county had on-duty San Antonio police officers charged with murder. Now we have 3. So who do they decide to put on the case? Somebody who says, I have no experience in the use of deadly force. Judge, with all due respect, that's all this case comes down to, is the use of deadly force. And he even said, you know what, at that academy, we have plenty of people who are experts in the use of deadly force. He didn't even pick up the phone to call one. The state decided to put up in a case that is singularly about the use of deadly force, they decided to put on the stand a detective who knows nothing about the use of deadly force. And their expert, Mr. Joyner, is sitting out there in the seats over there. They chose not to put him on. There has been no testimony as far as the use of deadly force, except he had to agree once he was shown the videos, slowed down, yeah, it was justified, it was legitimate. So the murder case has been undercut, and is Judge Bemperard and Judge Beery. Judge Bemperard watched these videos, just like this jury did, just like the court did, and under a lesser standard, found that these 3 officers acted reasonably and they acted appropriately. And there is no distinction, there is absolutely no distinction in the law between the United States Constitution, the Texas Constitution, and the Texas Penal Code as to what reasonableness means. There is absolutely no distinction. Those 2 federal judges didn't let, Your Honor, I suggest that this court should not allow this abomination to continue and allow this case to go to a jury.
And to be crystal clear, we're asking that the court grant an instructed verdict for all defendants of not guilty for all charges.
Mr. Cifuentes laid out all the facts, and I guess what I would just like to highlight is that Mr. Del Prado is in their argument that, as the court knows, you know, because I think there used to be a school of thought, not from this court, but there used to be a school of thought that, I mean, if the defense is bringing defenses, then the state has proven their elements of whatever they've proven, and there can't be a directed verdict. But I know, as the court knows, that the test is really, could a rational juror find beyond a reasonable doubt that the justification in this case did not apply? And so all those facts that Mr. Cifuentes has in his things we've gone through throughout this trial, where that culminates is that a rational juror, having seen and heard all of those things, a rational juror could not find beyond a reasonable doubt that the justification does not apply in this case under Chapter 9. You know, and in particular to Officer Alejandro, the state did not bring any evidence at all that he shot Ms. Perez. And so without having that, that would put him in the same position as Officer Villalobos, which means that the murder, just on that basis alone for him, should be directed out. However, Sergeant Flores, as they've talked about, as Mr. Del Prado discussed, Sergeant Flores, his charge of murder, it's the only testimony that was uncontroverted in the record was that he did not intend to kill, that none of these officers intended to kill. And I also asked the question, none of them intended to seriously hurt her. And they answered, and the officer answered, the detective answered that he agreed with that, which would go to the second paragraph of murder, which is, you know, intend to cause serious bodily injury, commit an act clearly dangerous to human life, causing the death. That second part is, if they're not intending to kill her and not intending to cause her, he has. Again, it goes back to the murder, both of the murder counts at a minimum should be directed out. However, the reason we're asking for directed verdict on all charges is because it goes back to, if the court as the gatekeeper of these facts and everything the jury sees, and if the court has seen, and if the court can decide, if any juror found beyond a reasonable doubt that the justification didn't apply, would that be rational? Could a rational juror find that? And with everything that Mr. Cifuentes has read, a rational juror could not. With the state of the state's case as they have presented it, it is telling that as far as the justification goes, and we talked about Mr. Joyner being in the courtroom, Mr. Joyner has his opinion as to reasonableness, but he believed, and Mr. Joyner put in his opinion, that the officers were lawfully there and entitled to be there. The state had decided not to call him and went with a theory that it involved a matter of law and a matter of mixed law and facts, which is only for the court to decide, which is how we got to this instruction. Their theory was based on that. Not once in the opening statement or throughout their witnesses while that theory was going, did we hear that that they believed that their justification didn't apply, or that the officers weren't being threatened with deadly force. I think that it was an acknowledgement that they were. And once the instruction went out that they could not rely to get a warrant in an unlawful arrest, that's when we started maybe hearing something about it, but still not necessarily controverted. The things that Detective Soto stated and the other witnesses that they called, basically every witness that they called, agreed that they were being met with the threat of deadly force. And then the thing Detective Soto stated about the intent of the officers that he testified to and was not controverted is that they did not intend to kill, they did not intend to seriously injure Melissa Perez. And so with those things, as I said, the murder charges specifically should absolutely be directed out for what I said, and the arguments of Mr. Cifuentes and Mr. Del Prado. But additionally, all of these charges, the only way it could go forward with the jury is if the court makes a determination that a rational juror, based on the evidence in the case that they presented, could find beyond a reasonable doubt that they're guilty.
Judge, just to complete the record, but in the name of parsimony, we agree and join in all the arguments of counsel.
Your Honor, with respect to the arguments of counsel, talk about the federal court opinion, which of course is not final and subject to appeal, but it's not an application of Texas law, and we've been through this argument multiple times or so. It's an application of federal law alone. It has nothing to do with even completely irrelevant, and it's not in evidence, and it's not for the jury to consider. That argument is specious, as Mr. Cifuentes likes to use. With respect to the elements of each crime, we'll start with Alfred Flores. Alfred Flores is charged with murder in count 1. That on or about the 23rd day of June 2023, he, with intent to cause serious bodily injury to an individual, namely Melissa Perez, did commit an act clearly dangerous to human life that caused the death of Melissa Ann Perez, hereinafter referred to as complainant, by shooting the complainant with a deadly weapon, namely a firearm. Those elements were on video, multiple by the defendant in his written statement given to the police. This issue about whether or not his intent to cause serious bodily injury is judgeable by the fact that he fired 3 times into her abdomen or towards this person. And for him to raise self-defense suggests that he's saying, I did it. It's a confession and avoidance defense. I did it, but I was justified. A rational jury could find that he indeed did intend to shoot her, believing that was his means of stopping her from getting to him. That is not an issue in dispute whatsoever. Paragraph B is the alternative way of committing murder, with intent to cause, intentionally or knowingly causing the death. An officer, and this is probably worth saying, who's trained in shooting, who has a firearm, who carries it every day, is reasonably certain that death will occur if you fire multiple times at a person running at them. there's no dispute in the evidence that he did exactly that. It's observable and perceivable on video, and that he used a deadly weapon, namely a firearm, in doing so. With respect to the other charges, and I'll go more quickly. And no question from observing the video that defendant, Albert Flores, did intentionally, knowingly, and recklessly cause bodily injury to her. Bodily injury includes death, by shooting her with a deadly weapon while acting under the color of his service as a San Antonio police officer. All those elements are proven without dispute. Likewise, the fact that he shoots projectile at her with a deadly weapon, not in dispute. Count 3, aggravated assault by a public servant by threat. He fired 3 times. He only hit her once. The shots were certainly a threatening conduct towards someone who was aware of him, of her shooting at him with a deadly weapon. Count 4 was manslaughter, which we abandoned at the beginning, and that will need to be removed from the jury charge. And then finally, deadly conduct. From the evidence, it's perceivable. Albert Flores, Melissa Perez, and that he was a public servant acting under the color of his employment. Again, all those elements are proven, admitted to, testified to. Eleazar Alejandro, in the same way, he fired at her 10 times. From the evidence, they make a suggestion that there is no evidence that any of his bullets struck her. Well, it's before the jury, in fact, of a that shows him firing right in the situation where her arm is raised, where the wound occurs, right there. And the medical examiner talks about the wound that Sergeant Flores fired, and we know that Sergeant Flores fired that wound because the bullet still in her body was a downward trajectory. We know that the bullet that struck Melissa under her arm was an upward trajectory. And just looking at the size of these 2 men, we can understand why one is downward and one is upward. And a rational jury can make that same determination that he had fired that bullet. And again, there's no dispute about whether or not, just because he tried life-saving measures afterwards, that his intent in shooting at her 10 times, if he indeed perceived that he was doing so to stop her, was reasonably certain to cause her death. And the same arguments, the same evidence easily establishes that he knowingly discharged a firearm in her direction, and that all these things occurred in Bexar County. Nathaniel Villalobos is charged with 2 crimes. He's charged with aggravated assault by a public servant by shooting at or in the direction of Melissa Perez with a deadly weapon. Uncontroverted. Fired 3 bullets, observable from his video, into a wall where he could not see her, in which she was on the other side, slowly slumping down. A rational juror watching that video could say he missed her head by perhaps this much. That thing that they keep mentioning happened. That's what happened, missed her by this much, the bullets. And had she still been not received a fatal blow and could have survived, those bullets would have killed her. But for that matter, he is responsible for firing those bullets downrange. As Chernak says, every officer is responsible for any bullet that leaves their gun fired downrange. And he, in the evidence, knew that door was locked at the time he fired his shots. He knew it because you can see it on the video, him reaching for that door twice and unable to
address the court.
One at a time.
Quit looking at my client in some sort of like dramatic fashion.
And I'd ask you to stop looking at our complainants when you're making your argument.
All right.
We already know that's
Yeah,
same
let's-
thing, Judge.
Same thing.
Let's hear the argument.
Anyway, Your Honor, that shows that evidence shows a rational juror could find that he indeed knowingly discharged his weapon while then and there a public servant under color of his employment as San Antonio police officer. is proven. So the argument then is, and for the court to decide, is could a rational juror believe from the evidence beyond a reasonable doubt that the actors did not act in self-defense, they were not justified? Well, unlike a number of cases we have, they're basically testimony and swearing matches and credibility determinations. This jury has before it the whole event from beginning to her death. And they can see and they can hear all the showing up to a situation that began as a property crime, and all these men, one woman, well-conditioned, trained, equipped with multiple devices, tasers, asps, shields, non-lethal force, less lethal force. They had all these options, the beanbag thing. And they were, because of the decisions made, particularly the decisions made by these three men, unable to take a 41-year-old woman, 47-year-old woman, 5'1", 140 pounds or about, into custody without killing her. That's for the conscience of this community to decide whether or not their actions in requiring and pushing the dominoes down to that result were reasonable. That an ordinary and prudent person would have made those same decisions that put them in the box where they felt they had to kill her. I suggest to you, yes, a rational juror watching all of that evidence, ignoring all the testimony, ignoring their statements, looking at all the video, could come to the conclusion of, yeah, this is not a justified killing. This woman should still be alive. And based on that, the motion should be denied.
Judge, just for one point, Ben, just for one point of clarity, Judge. There were 15 officers there, and so theoretically, since the Detective Soto was arguing the law of parties, under the law of parties, they're all guilty. That's number one, and we know that that's not the fact. Number two, when Sergeant Flores, as the evidence showed, Judge, and uncontroverted, and Officer Villalobos were setting up for this less lethal plan, the initiation was from, unfortunately, Ms. Perez. They didn't just come in there like a bunch of rogue officers just breaking in the door and just shooting. I mean, there was a plan. They were following the 5 C's. Uncontroverted. No expert testimony from them, nobody. Matter of fact, they're also on cross-examination agreed with their behavior and the behavior, unfortunately, of Ms. Perez using deadly force, a hammer being. The court knows that, but I wanted to make those distinctions, Judge.
Your Honor, in response to the state's argument, and also to echo what Mr. LaHood said, I want the court to read part of Judge Ben-Parad's report, and the court still hasn't decided whether to take judicial notice of the opinion in this stage of the proceedings for this limited purpose. And if I may sit down and read from that opinion. On page 12 of the opinion, this is what Judge Ben-Parad says. An officer's use of deadly force is not excessive and thus no constitutional violation occurs. I realize that doesn't address the Texas Penal Code, but the following part of the sentence mirrors the Texas Penal Code verbatim. Essentially, when the officer reasonably believes that the suspect poses a threat of serious harm to the officers and to others, and it quotes case law. Then it goes on to state whether an officer's belief to that effect was reasonable is measured in objective terms based on the totality of the circumstances as then known to the officer. And it cites Barnes v. Felix. Noteworthy at the beginning of this trial, Mr. Harris cited Barnes v. Felix to cite the proposition that totality of circumstances controls. Since that Barnes v. Felix and totality of circumstances controls, the state has essentially admitted that this analysis analysis is what's controlling. What Judge Bimperod then goes on to say is, and this is an explanation of the totality of circumstances, thus the court considers the severity of the crime, and the severity of the crimes here was several aggravated assaults against peace officers, attempted murders of peace officers, and the criminal mischief. So all of them together were a series of serious crimes that happened in a span of approximately 22 minutes. And then the sentence goes on. I'll restart the sentence just to be sure. Thus, the court considers the severity of the crimes committed by the suspect, any prior actions taken by the officer, such as giving warnings or trying to control the encounter. In this case, there is sufficient evidence to show that many officers asked Melissa Perez to come outside so they would not have to use force. They pled, they cajoled, they tried to de-escalate, they tried to unlock the door and so forth, but despite their repeated efforts to control the encounter, she refused. So I'm going to repeat some of the sentence and then continue. Any prior actions taken by the officer, such as giving warnings or otherwise trying to control the encounter. And then it goes on to say, the suspect's own conduct is always relevant because it indicates the nature and level of the threat she poses either to the officers or others. So under that standard, the totality of circumstances standard, which the state has conceded is applicable, and which the witnesses have testified, officers. Under that standard, Melissa Perez has shown that the nature and level of the threats that she poses by her conduct, by the 3 hammer swings before 20207, that she was in fact a dangerous threat to the officers and others. Then it goes on to continue. Of course, the situation at the precise time of the shooting will often be what matters most, but earlier factors may bear on how a reasonable officer would have understood and responded to later ones. So what's important for Judge Bimperod and for this court to note is under the totality of circumstances, yes, the moment of truth, the moment of 202:15 is relevant, and there's undisputed evidence that she was threatening deadly force and deadly force was imminent. However, when it says that earlier facts and circumstances may bear on how a reasonable officer would have understood and responded, the fact is that if you show an intent to kill someone by swinging a hammer at 2 different officers, a reasonable officer 10 minutes before the shooting, that intent has remained unchanged. Moreover, she had yelled out to others that I'm not shoot me, fight me, and so forth. The opinion goes on to say the use of force is judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. And allowances must be made for the fact that officers make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. In this case, what we have is evidence replete with satisfying that what the department has done through Detective Soto is attempt to judge 20/20 vision hindsight because they didn't see the facts correctly. Even 2 years and 4 months after the fact, they did not see correctly what happened with the benefit of hindsight. And even Detective Soto admitted that over the span of 4 months, he provided false information in his affidavit, false information in his prosecution guide, failed to correct the false information, did not obtain one of the videos from Travis Thompson until November 6th after he staff. Thus, there's no proof that he was even able to judge these officers with the benefit of 20/20 hindsight. So, explain, Judge Perez's court case goes on to explain that the officer's use of force was imminent, it was immediately necessary, and in later pages he talks about how when Melissa Perez was charging with the hammer at the officers, that any reasonable officer in the shoes of the defendants, as seen from their body cameras, that Judge Benperot, even he was able to see that the use of force was reasonable from their perspective. Beyond a reasonable doubt, the justification of each defendant for all of the charges alleged against them, this court has granted the motion for instructed verdict of not guilty on all counts for all defendants, and that's what we would ask the court to do. And Mr. Del Prado wants to address the court.
Just briefly, Your Honor, what I'm suggesting the court needs to zero in on with total alacrity to meet this new theory from the state is, at the moment deadly force, they were met with deadly force, was it their reasonable belief that they could use deadly force to protect themselves or another. That's it. The state, in their newest evolution of their theories, because the court has ruled out, I think as Mr. Cifuentes has pointed out, 4 of them up to this point. Now, says, there should have been another plan. They should have waited. There could have been alternatives. That may be public policy, and for an office that was telling officers in this case that she would have been justified in killing them with a hammer, if that's the public policy that this district attorney's office wants to go forward with, then they can propose that. But that's not the law now. The law is Graham v. Connor for the country. The law is 932 under the Texas Penal Code. I would ask the court to have them offer up with specificity what law or what statute are you relying upon to make this argument that because, in their belief, another plan should have been called for. They should have waited. An attack, 4 deadly attacks aren't enough. You got to wait. It's, as the gatekeeper, Judge, we're asking you as the gatekeeper, because it's going to be too confusing and nebulous when they bring up this again. Well, and this jury may think, I guess, they're maybe we have to specifically point out what law, what statute, what case law they're relying upon, because they will not be able to provide any.
And I want to reiterate what Mr. Del Prado wisely said and put it in this terms. The last argument that the state has propounded was public policy demands that. That may be an appropriate argument for a jury. Improper argument to make to the court, because in essence what they're doing is trying to cower this court by making this court be fearful of what the DA ruling upon the law. They have failed to disprove beyond a reasonable doubt the defense of justification. It's not this court's fault or responsibility to satisfy public opinion, and that's just shameful that they are trying to somehow or another cower this court. And I would hope that the court stand up to such a shameless argument.
I make no apologies for our arguments, Your Honor, on behalf of Melissa Perez and our community and the behavior of the officers in this case. None whatsoever. Your Honor, a rational patio or so, that all they feared was at least was a minimum bodily injury and not serious bodily injury or death. They didn't have their guns pulled. They approached the door with their hands. And this is despite all the knowledge they had known before. So despite all the hyperbole, Melissa Perez in no situation had tried to kill anyone. Had tried to kill anyone. The most that she had done is thrown a candle, let me say without any wax in it, a candle at an officer's arm. That's not okay. That's not okay. But it's not an application of deadly force. It's an application of force. It's an application of force alone. You can't respond to an application of force with deadly force. The fact remains is she's behind a wall, a solid paned window, and an obstructed window on her left. And a rational juror can look at that and go, at the time they shot her, they weren't in actual danger. Age, her size, her limited, having only an impact weapon or so. Given the manpower that they had, given the tools they had at their disposal, given that Officer Villalobos says, I'm not afraid of the hammer. Given Officer Chernak says, I'm not afraid of the hammer. A rational juror could decide that they were not actually afraid of serious bodily injury or death when Officer Alejandro overreacts and starts firing at her.
All right. I'll deny each of the defendant's motions for a directed verdict. I will take judicial notice of the federal court opinion under Rule 202 for purposes of this hearing. Anything else? All right, let's take a short break, then we'll bring the jury back.
John, I did have just kind of a point of order. So we expect to begin our case. My understanding, I just want to make sure that everybody's on the same page. I believe that one of us will start our case in chief. The other two will be able to cross-examine the witness that one of us calls. What order did the court want that in? So, for instance, if it's our case in chief and Officer Villalobos' case in chief, and we start that, do you want all the defense to finish their questioning and then go to the state, or does it go to the state and back to the defense?
You know, Your Honor, it's been argued multiple times as a joint defense agreement. I don't believe it's
They have the right to
necessary for them or allowable for them to be able to cross every witness that's not adverse to them. That would be my point.
They have a right to confront every witness that testifies.
They can confront, they don't necessarily be given the opportunity to lead.
That is not confront.
And they should be given the opportunity to lead because it is a joint defense, but witnesses can say something that it more relevant to one than the other, and each defendant should have the opportunity to be able to confront any witness using leading questions. Of course, when it's but it's a cross-examination for every other person or every other part.
It's not a separate case in chief, Your Honor. It's a joint case in chief for the defense on a joint agreement. I know no.
It's the Sixth Amendment to the Constitution is the authority.
Do we all intend to go A, B, C, or just in a different order? Or?
Our idea is that our case, that the Villalobos case will direct the first two witnesses and then rest. And then the Sergeant Flores will direct the remaining witnesses and they will rest, and I believe that will cover the Officer Alejandro, and they will not have a case in chief, is the idea.
Okay, so then we'll do that. So we'll start off, and then as it relates to whether or not other defendants would be able to lead versus ask the open-ended questions. Let me think about that for a couple minutes. Let me ponder that over the quick break. And then
not waiving a presentation of our case in chief, but how, since we're going to adopt testimony of defense witnesses to that extent, I would agree with what Mr. Goss is saying, and in the course of the trial, we would like to reserve our ability to call a witness and not give up that right to call a witness.
Yes, yeah, and we'll do that. I mean, each of the three defendants can present a defense and call your own witnesses.
Yes, sir.
So then the question for me becomes, is it gonna be joint defense, or is it gonna be the other defendants get the lead? So let me think about that one issue.
Yes, sir.
All right, let's take a short break.
I said,
The 17th.
did I?
The 17th, oh my God.
You still think we're gonna be done before the 8th?
Yeah, I think we're done next week.
I think that's exactly what's gonna be a problem.
What day's the 8th?
Friday. Well, that
Before
Friday, I
Friday.
think that Friday. Yeah.
Man, you might, I don't know.
I bet we'll be arguing by Wednesday. Well, actually, I say all this because I don't know the court schedule. Are we doing full days next week? We have a lot of calls.
Oh, okay, well, that's worse. Yeah.
Yeah, so we'll probably, most likely, I think we'll probably start at 10:30 on Monday.
Okay.
And then Tuesday and Wednesday is our busiest day, we'll probably start at 1:30.
Okay.
And then Thursday and Friday will be full.
Probably all day.
Then we'll be arguing.
Okay. Okay,
I
we'll
bet,
see.
I bet no late.
Thank you, Christian.
And hopefully they start deliberating. Cause then if it goes into Friday and then sequester, then.
Talks everyone's weekend out.
Yeah, and it'll be.
It'll be fast. It'll be fast.
Or at least start, like,
Either Thursday or Monday. Like, I think we started at 11 or Thursday.
Yeah.
It would make your mind.
yeah, if they start Friday, then hopefully it's early though, like where they start deliberating like 10 morning, not, because sometimes we'll start deliberating like at 3 in the afternoon and we're like.
On every felony, it's gonna be at least a couple hours, no
Yeah.
matter what it is, 'cause they're taking their job serious.
Yeah.
So this one especially, it's a big one.
But then Monday would still suck for us, because we deliberate Monday, Tuesday, is a holiday, it's Veterans Day. Fuck.
Yeah, scratch that itch, got it in the record. Hi. Super tired today. I can't drink enough coffee. It's really good. Yeah, exactly. Yeah, I think so.
Thank you.
It's dust.
Yeah, a little Swiffer up there?
Yeah.
You ever hear the light?
Yeah, they take forever.
It's a different guy. I'm the light guy.
Yeah.
Does things out.
Lorenzo's in custody.
Oh, yeah.
You
Yeah, Trisha said he.
sent a little letter.
Oh, your letter's good?
Yeah, she wants somebody to pick her up.
That's from Joe?
Yeah.
Not me.
Yeah, I'll send somebody to pick me up.
She was in her mental health document, she was pretty checked. Oh, no. But she would come, like, every time she'll come, she wanted to talk to us, just to see. We should come in after bus passes here, like, every so often.
That's why she kept coming in?
For the bus passes. I don't even know who gets them out.
Yeah.
Judge, I also want to remind the court that Mr. Nisbet's going to do his opening statement as well, so just so you can go through it.
the whole block came out.
Everything. So now you're all greasy.
That's why I said, hold on.
Yeah. Hold on. Well, that's when you gotta start to rub your neck.
Oh, yeah, true. That's right. That's
Get it
what
all
I
off.
said.
Get it all off.
Okay, now I'm ready.
Okay. All right, let's go back on the record real quick before the jury comes out. All right, so just to make sure we're on the same page, so we'll go, so Mr. Goss, your side will go first?
Yeah,
So
yes, we do have two witnesses,
All
I
right,
believe, we'll call.
all right, so you call your witnesses, and, I would say then the state would cross, and then each other defendant would cross under the Constitution.
Yes.
The Sixth Amendment issue, I think.
And honestly, that's how I figured that it would probably go, and so I think we're on
Yeah.
the same page and didn't even discuss it.
Yes, it'd be direct, and then cross, and then cross.
Are you guys all right for the jury? May be seated.
All right, welcome back, members of the jury. We'll go through until one of you pretty much advises me that you're ready for lunch, and then that's when we'll take a lunch break, all right? And we'll try to keep lunch as short as we can today. All right, so when we last left off, the state had rested. I advised you, after I swore you in, that once the state has rested, then the defense, or defenses in this case, if they choose to, can put on a case for you, as the case you choose. So with that, Mr. Cross?
I'm sorry, Judge, I believe Mr. Nisbet is gonna open on behalf of
yeah.
Judge, I reserve, may I open to the jury?
Yes.
Thank you, Your Honor. Good morning. They had a duty to arrest. They had a right to go home. I want to thank y'all for your grace and your time and all your attention in this trial. It's hands down the longest trial I've ever done. Probably the longest one y'all will ever do, okay? So in opening statement, I'm going to talk to you about what the evidence is going to prove. But the case isn't really over yet, right? So what the evidence is going to prove is on June 23rd, 2023, there was a call, officers responded. I know y'all know the facts at this point, okay? And the evidence is going to prove that really two things happened on June 23rd, 2023. Two things are going to be proved to have happened that day. A tragedy for this young lady's family, lost a mom, lost an aunt. But the second thing that happened was a rush to judgment. And that doesn't mean we have to have a second tragedy where these good officers are punished for self-defense. Mr. LaHood was very clear in walking y'all through this case that there were different scenes, right? The evidence is going to prove there was different scenes in this case, right? Chapter 1, Officer Rojas responds. He did not handle the scene, he did not handle the communication, and he did not handle Robert Ramos. The evidence is going to prove that, and that's a problem. Chapter 2, Jonathan Salinas arrives, and now you have felony assaults. The evidence is going to prove you have violent felony behavior on police officers. Melissa Perez was a very high risk. The evidence is going to prove that E-Tone was a 15-officer response. And the evidence has shown they only called 3. Finally, you have Chapter 3, where Alfred, Nathaniel, and Eleazar show up and attempt to arrest the suspect for multiple violent felonies. Melissa Perez attacks, and they fire in self-defense. Chapter 4, we brought you Detective Ronald Soto, and I'm going to try to keep a straight face when I talk about him, okay? He brought you his investigation. Mistakes, omissions, and errors. Now the judge is going to give you the law in this case. You remember in voir dire, I put up a picture of the judge. It told you the judge will instruct you on the law in this case, right?
And he's actually already given you a very interesting piece of law. And so we're going to go through it because I know he read it to you all that one day, but sometimes it's hard to catch all of that legal jargon. Okay? You have heard testimony and arguments regarding the issue of whether the defendant officers were required to obtain an arrest warrant before entering the complainant's apartment. Okay? That's coming from the state. And as a general matter, whether or not police officers are permitted to enter a person's residence to make an arrest without first obtaining an arrest warrant is an issue of law for the court to decide, and is usually the subject of what's called a motion to suppress, which the evidence has been proving and you all have heard a lot about. It is not an issue for the jury to decide in these cases. The evidence is going to prove that. Makes it real easy for y'all, right? All such evidence is irrelevant. You are instructed to disregard and all the evidence related to the subject of whether these defendants were obligated to obtain arrest warrant and are not to consider such evidence for any purpose. So now y'all have a complete picture of what the judge instructed you the law was, okay? But there's going to be more law that comes, and at the end of this case, the judge is going to give you the final jury charge, and that will say resoundingly that the burden of proof is on the government. Okay, the evidence is going to prove they have to show murder, the intent to commit murder, aggravated assault. They have to prove all that beyond a reasonable doubt, the highest burden we have. But they also have to prove beyond a reasonable doubt it wasn't self-defense. It wasn't justified. It wasn't defense of a third person. And that might get a little bit confusing. Lost in the time and lost in the details, but I need to remind y'all the evidence is going to prove and the law is going to be that burden rests with them the whole time. So if you find yourself thinking, geez, the defense are making a lot of good points, we don't have to. But we're going to show you in the evidence that it's so clear that we are bringing you the truth. And then we're going to bring you some defense witnesses. Not our burden, but we are. We're going to bring you a gentleman named Mark Sawa. Okay? Highly decorated major, SWAT, mental health, CIT training out of Austin PD. 7 years in the Valor program with the feds. Now is a use of force subject matter expert and instructor. Goes all over the country teaching police departments the right way to do it. Rewriting the way they do it. Force and OIS cases can tell you about Chapter 9 of the Penal Code. Can tell you about police investigations. I don't know why I'm holding this. We're going to bring you Mark Duke. Where are you, Mark? Raise your hand for me. There's Mark Duke. 28-year seasoned SAPD officer, retired homicide detective. 900 death investigations. It's a staggering number. 450 as the lead detective, 27, not the first, 27 officer-involved shooting investigations. Mark's going to tell you about how we investigate OIS cases. He's going to talk to you about the Penal Code in Chapter 9. He's going to talk to you about criminal profiling. Then we're going to call Lisa Miller. Lisa. There's Lisa. 28 years with SAPD, retired. Patrol sergeant, SVU detective, homicide detective. 21 years, honorable service, U.S. Air Force Reserves. Lisa's going to tell you about how you investigate a major crime. How you interview and then go into reporting techniques. And she's also going to talk to you about something that's really important. It's called confirmation bias, right? And how an investigation needs to be objective from the very start. You don't just walk up and have some concerns. We're going to bring you a gentleman named Ron Martinelli, who has had really 3 careers. He was a retired police officer. Then he did a series of special assignments with all the groups y'all see there. And since then, he's been a law enforcement training and police practices expert. Now, Ron's really interesting because he uses actual forensic criminology and the science of human factors the science behind the OODA loop, right? I see it, I orient, I have to decide, I have to act. And he brings with him a gentleman named Angelos Liligalou. I hope I got his name right. Thank you. He does photogrammetry. A wizard at reconstructing and remapping through computer 3D real-time reconstruction what it actually looked like in real time, what it actually looks like to the naked eye. A 50mm flat naked eye lens will show you a view that looks very different from a concave fisheye body cam, which tends to distance and distort the farther you get away from it. Finally, we're going to bring you Thomas Butch Majeka. Butch, this man is the Santa Claus of law enforcement in South Texas, okay? A 47-year lawman, 33 years with SAPD, homicide, 2 years at the Bexar County District Attorney's Office on the Capital Crimes Group. Still working, 12 years, he's a lieutenant out in Kendall County, Spurn. He's going to tell you about homicides and OISs. He's going to tell you about the Penal Code in Chapter 9. The facts are going to prove that these gentlemen were justified. The last chapter of this story, members of the jury, is going to be written by you. "847 days. These gentlemen have had to live with this. At the end of this case, we're going to come up here and we're going to ask, it's time to let them go home. Thank you.
Your Honor, the second mark, please.
I do swear you in. Do you solemnly swear or affirm that the testimony you give in this...
I do.
All right. You can introduce yourself to the jury and spell your name for the court reporter, please.
Hi, I'm retired SAPD homicide detective Mark Duke. That's M-A-R-K D-U-K-E.
Is everyone here okay? Can you tap on that? State, I'm sorry, defense?
Yes, Your Honor, and I know you probably said state because we're used to having Mark Duke testify for the state. Mark, you and I know each other because we've known each other for a decade or more. Right?
That's correct.
Go ahead.
As a matter of fact, I've worked with every attorney at this table and both Mr. Luna prosecutors, with the exception of Mr. Cifuentes, during my career.
And I want to talk about that career, and you heard Mr. Nisbet, you heard him talk about and kind of tell the jury some of your qualifications. I want to go into that a little deeper. So tell us first about the
well, my first 15 years were on patrol. The last 7 years as a patrol officer, I was an FTO, a field training officer, which means I would train the recent graduates from the police academy and teach them how to apply what they learned in the academy to the streets. In 2010, I tested and was promoted to detective. I went straight to homicide. I was in homicide from 2010 till I retired in 2023.
And so the time that you spent in homicide, right?
Correct.
And in that time that you spent in homicide, tell us about the types of investigations and how many of those investigations did you do?
homicides, capital murder, all suspicious deaths, overdoses, intentional, accidental deaths, suicides, anything that had the potential to be unnatural or criminal in nature.
And the, as far as officer-involved shootings, I know that you were here and you heard Detective Soto testify that he was assigned, his first one was this one. As far as officer-involved shootings, at the time that you were in homicide, was that common as well back then for somebody like you to also investigate officer-involved shootings?
When I initially went to homicide, we had a officer-involved shooting team, and it only consisted of 7 officers. I think we had 14 or 15 homicide detectives, but only 7 of them were assigned to the shooting team. It became very burdensome because it didn't count in your rotation as being a homicide. So theoretically, you could get an officer-involved shooting one day, and later that day or that night, get a homicide case. So it became it was overwhelming. So they decided to extend the shooting team to every detective that was in homicide that was working murders. So during the time I was in homicide, that changed from a 7-man shooting, officer-involved shooting team to everyone in homicide was on the shooting team.
In a department like the San Antonio Police Department, and you can answer based on your last experience, which would have ended in 2023, but in a department like that, how many homicide detectives are in San Antonio Police Department?
Well, to be a homicide detective is a pretty broad term. If you're talking specifically about how many detectives work murders, because some work ag assaults and threats and things of that nature, but homicide detectives only work things that have the potential to be a violent or criminal death. And when I first went to homicide, there were 2 teams of 7, 14 detectives. I think it has since grown a little bit. I would say I would guess there's probably been 4 more added. That could be.
And so, going back to your
Had 2 teams, 7 on each team. One team handled half the week, Sunday through Wednesday. The other team handled Wednesday at noon through Saturday. And within those teams was a rotation. If you're up for the next homicide, you catch every unnatural or suspicious death until you catch a homicide. On average, the suicide rate is 2.5 times that of the homicide rate. So you can expect to get, San Antonio is a military city, so it's a little higher. The suicide rate is a little higher, so it's probably around 3 times the homicide rate. So you're going to pick up 3, maybe 4 suicides before you get your next homicide, and sprinkle in some accidental deaths and some overdoses. You may end up with 4 or 5 death investigations before homicide. So it's very busy.
Sure, and just so that we understand that, just because something comes in and it seems like a suicide, you do a full and thorough investigation on that, just like you would any other case.
Well, you have to, because you only get one chance to collect the evidence. Once you release the scene, it's gone. So if you think it's a suicide today and find out tomorrow it's a homicide, unless you've done a complete, at least collection of the evidence, you've lost things that you need for your investigation.
And so when talking about the shooting team, so if there were 14 detectives, but only 7 on the shooting team, what differentiates those 7 as far as unless, supervisor's brother-in-law or something, you know what I mean, unless there's some other reason. Theoretically, the supervisor is going to put on that shooting team, investigating officer-involved shootings, the more experienced, the people who have had more homicide investigations, people who have had more experience with officer use of force and those types of trainings and things like that, those would be the people that would typically be assigned.
Correct. Just to be clear, though, that's the way it was when I initially went to homicide. When this shooting,
right, and that's kind of the point I want to make is the way they used to do this. Somebody like, well, I haven't finished yet.
Let me read a question.
So the way that they used to do this, according to what you're saying, it sounds like you're saying somebody like Detective Soto would never catch one of these for his first case. Would somebody like Detective Soto ever catch a case like this for his first case in the way that it
everyone has to have their first case at some point. So this could have been his first case, but you would want to make sure that there's someone certainly on the shooting team or that has a lot of experience shadowing him.
Right. And so, like, you were describing FTOs, like that you were an FTO. Can you tell us what that is?
Well, on patrol, a field training officer is an officer that is assigned a recent graduate from the police academy, and they've learned laws and a lot of tactics, but they've never really been able to apply that on the street. And it's a whole different. Field training officer helps them make that transition from the academy to being a street police officer.
And it sounds like what you're describing, that's for patrol, but as far as like a shadow detective to help somebody with their first shooting, would they operate similarly to like an FTO and try to help them and train them in how to do that job?
They would. There's no official designation, but yes, they would shadow them. Someone with experience should shadow them on quite a few cases, and normally they go out with them on call-outs. They would, and vice versa. They would go with whoever they're training with on their calls as well.
I called you, and I knew you had been retired. I called you and I asked you if you would be willing to look at this case and give me and tell me what your opinion is about the investigation and about some of the facts that we've seen. And you remember that I did that?
I do. He asked me if I would be willing to look at the case for the defense. And it's a funny story. When we were first here for the trial,
Object to non-responsive.
Well, let me ask. I can rephrase the question. Can you tell us what you were when you were first here for the trial?
Jason Miller, who I worked with in homicide, said, "You said you would never work for the defense." I said, "I did," and that's something I've said. That's something that I've never done. I never intend to do again. I'm very happy, retired, riding off into the sunset. But I did what Jason asked. And I said, "Okay, I'll look at it," and more as a favor to him, because we had worked quite a few cases, murder cases that were big cases, and they were very important. So as a favor to him, I said, "I'll look at it."
Now, can you tell us what you were able to review? Basically, I gave you everything, access to everything that we had that the state gave us in discovery, right?
Right. I looked at the case, and I was very surprised at what I saw that resulted in the decisions that were made. And I felt obligated, because of what I perceived as a huge injustice, and agreed that I would work with.
So I'd like to talk about that. In reviewing, did you review all the body cams that we had available from the officers that were on the scene?
I did.
Did you review the reports that were made available to you, as far as the officers who had written reports, or reports that were generated like IDR, those other things that we've seen as evidence in this case?
I did.
And then you've been sitting here since the first day we were here, and you have seen.
Yes.
Now, in your opinion, was this a thorough and well-executed homicide investigation?
No, not at all.
Okay. And in your opinion, was this a thorough and well-executed officer-involved shooting investigation?
No.
All right. So I want to start talking about that. And I want to take you back to the scene. So from the perspective of somebody like you on the officer-involved shooting team, when you make a scene like that, tell us what you believe is important for somebody in your position if you were to make a scene, as far as evidence collection, preservation, those types of things. Walk us through how that would happen if you were investigating.
So the first thing that you've got to understand is you've got to collect all the evidence. You got one shot at it. And one of the things that I would always make clear to new detectives is I had a thing that I would do to try and make the point with them. The first thing you've got to do is you've got to collect all the evidence. And you know those 2-hole or 3-hole paper hole punchers? I would take one of them and go over to their desk and dump it on the desk. Made a big mess. When they were gone, of course. And I'd leave them a sticky note and say, you've got to collect the dots before you can connect the dots. That's very important. And you only get one chance to do it.
And so when we heard testimony that Detective Soto went and saw that CSI was doing CSI things, and as the lead detective just left the scene and didn't instruct them, is that a normal thing for a lead detective to do?
Well, no. First of all, if you're the lead detective, you're responsible for that case. You may trust the CSI, and we have very good CSIs. You may trust them, but ultimately, if they miss something, it's on you as the lead detective. Okay? And it's your case that's either going to be made better or it's going to be insufficient. So we're constantly fighting the battle of, because we're human, of having preconceived ideas or being biased. So you're always having to make sure you keep that in check. I mean, it's just human. It's hard not to. But in this case, one of the things that should have been done, and I'll explain why, is the door that was broken into, it should have been fingerprinted. It should have been swabbed for DNA. The panel box. Well, why? She admitted to it. Well, it keeps people from later saying, well, we can't believe what she said. She said she was Elvis's daughter. She said that she'd been kidnapped by the cartel, that she owned the building. So what this does is this gives us physical evidence that says, no, she did tell the truth. Her DNA was there. Her fingerprints were there. These are stone, hard, cold facts that we have to lean on if we collect the dots. In this case, they weren't. You can even go further and say that there should have been impressions made of any tool marks so that when we search the apartment, if we find tools, we can match them. That also shows that she's the one that broke into the alarm room and pried open the door. We could have collected the were they cut by a knife? Were they cut by a there that we can match any tools that we recover to that. So there's a lot of things that could have been done that weren't done that would have eliminated some of the guesswork on whether she was telling the truth or not. There was also things missing from there. We know that alarm box had went out, which is often the case in fires. But the alarm system would still work because it had battery backup. We found some batteries, about 13 of them, we know they were in the apartment. Didn't realize it. There's a cart right outside her front door. There was a battery. It's about the size of this box. Like a big neon sign that says, "This does not belong here. Why is this here?" Wasn't collected. It could have been fingerprinted that says, this was taken by this person from this location. So we haven't even got to the shooting. And really, so is that important? What does that have to do with the shooting? Well, it was the whole justification of why the officers were originally called there.
Now, also, is it important under the totality of the circumstances that all of the facts and circumstances, like you're saying, about why the officers were there, what her state of mind was when they got there, and how that, what was going on, are all those things important to you and would they be important as a homicide or an officer-involved shooting investigator?
Well, of course, all the details are important. I mean, you've got to have the dots to connect them. You've got to have all the facts. To walk up and see shell casings on the outside of a scene and immediately say, I've got concerns. There are many, many legitimate reasons that explain why those shell casings are outside. That's the bias we have to protect against. And we have to do a full investigation. And they take weeks. Sometimes they take months. I've had cases that have taken years to work through not just the evidence, but for people to feel like they could come forward. You don't give up on the case, but you want to be satisfied. You don't want to rush to judgment. So just to talk about the investigation, sometimes it's necessary to make an arrest right away. Is this person a danger to our community? Do we need to put them in jail right away for public safety? Is this person a flight risk? Are they going to go to another country? Those are times when you have to make quick decisions. That didn't apply in this case. These officers weren't going anywhere. their whole career has been helping people. They're not going to hurt anyone.
I can ask another question.
Next question.
Could you continue, please, with your rationale for why these officers would not be a flight risk, and honestly, that there's no need to walk a warrant or put them in jail before a complete investigation?
These officers' families are here. Their homes are here. Everything they have is here. Why are they going to leave? They're going to wait and let the system work through this issue. And they're not a danger. They've never all their career they've helped people. I mean, that's what they do. When you have to make that decision to walk a warrant, you've got to have a good reason to do it, because there's two sides to every coin. If I make this decision quick, the payoff is I'm keeping this person from escaping, and I'm making the world safe. But there's a cost of not being thorough. And you've got to let the evidence drive the case so that you don't have investigative failures. So the risk in making a quick decision is you may not get it right. But sometimes that risk is outweighed for public safety or to keep from them being a flight risk. In this case, there was everything to lose and nothing to gain. Everything to lose, what I mean is getting the investigation wrong. And by making it quick, there was nothing to gain. The reasons that we usually make that decision to do it quickly weren't factors. So there was no reason to make a decision in a few hours of what needed to be done with this case and the officers involved in this case.
And so, Detective Duke, I think I know the answer to this, so you may educate me on it, at least in your experience. Like, let's say somebody starts a fire and it kills a person, intentionally starts a fire, and then the person dies in the fire. I know that there are arson investigators, but would homicide also come out and investigate those as a homicide in addition to arson, or does arson just do the entire investigation?
Normally, arson and homicide will work it together. Sometimes the death was not a result of a fire. The death may have occurred before the fire, so there's some collaboration there. But normally a fire death is investigated by arson.
So, and to bring that up, just so we can talk about it, like a case like when Ms. Viola Barrios was killed. You remember that case when that happened?
I
the lady
don't.
that was shot with.
Oh yeah, the bow and yeah.
With the bow and arrow.
Yes.
Right.
Yes.
So, and I think what you mean is that sometimes.
Leading?
Okay, I can ask. I'll rephrase. So, just so we can set up the next question, what you said was that sometimes the death happens and it's not from the fire. So, have you, in your experience, had cases where a person was murdered and the fire was set to?
And with the exception, the greatest reason for arson is to destroy evidence of another crime.
So in that, and I kind of want to bring that experience to bear as you're looking through this evidence and as a detective, kind of walking in the shoes of the investigation as it was done in this case. What concerns do you have about the fact that this fire alarm box, the wires were cut, and then the situation that was going on inside of Ms. Perez's apartment?
Well, in my training, I've been taught to look at things a little differently. I have 5 years of behavioral analysis training. And part of what we're taught is to ask the question, why? To look at the behavior at the scene and ask, why did the offender commit that behavior? The why leads us to the who. It tells us a lot. So the first thing I want to ask myself is, why did she cut the wires? There's a couple of explanations. One, maybe she was trying to keep these voices. She thought maybe the voices were coming through the wires. But maybe she had some other ulterior motive. Maybe she wanted to set the apartment on fire and for there to be no warning and no way to put it out. So these are questions that you have to consider, because there are logical explanations as to why she may have done that. When you go to her apartment, we can see that there's at least 20 candles in the apartment. They're lined up on every windowsill. They were lined up on the bar. For some people, maybe they're prayer candles. Maybe there's a good reason for that. But she did use one as a weapon. There was one burning in the bedroom where the bedridden old man was. So you've got to wonder, why did she cut the wires? Why did she take the battery back up? Why does she have all these candles? What's the reason? That's one of the things that I would consider.
And as part of, if you were investigating, would that also, because, you know, we're putting you in the shoes of an officer-involved shooting investigator, would that also go into the totality of the circumstances, the potential risk to others in that apartment complex? Would those questions you're asking go to the totality of the circumstances of why the officers were reacting the way that they were reacting with Ms. Bennett?
Yeah, I think, having said all that, I think you're left with the question, is it safe now to leave this situation without taking action? And I think it's reasonable to say no. You can't leave this situation the way it is, just based on what we've spoke about up until this point. Not even discussing the assaults on the officers.
Now, we're kind of at the point where, you know, as we're following this investigation, we're at the point where, as Mr. Nisbet talked about, you know, there's those kind of three separate incidents. So we're still at kind of incident one, cutting the fire alarm, and then she, you know, ran away from a detention and ran back into her apartment. Were you able to view the behavior of officers? And what is your opinion on his behavior and how he was acting with Ms. Bennett?
Well, he was kind of poking the bear.
Yep. And because he did that, did you see any evidence in your investigation that any of these men knew that he had done anything like that to her?
No.
Right. So, as an investigator, would you, as an investigator thinking of those facts, would you charge what Officer Ramos did with Ms. Perez to Officer Ramos, or would you charge it to them? Meaning, would you blame them for his conduct?
No, he has to take responsibility for his actions.
Right. And would it be fair for them to take responsibility for his actions, having no knowledge of those actions?
Of course not, no.
Right. So, we have that first scene, and now she's in the apartment. When we go to the second scene with Jonathan Salinas, you were able to view Jonathan Salinas, Officer Salinas, attempting to go on the window to unlock the door.
Correct.
Okay, so what is your opinion of the attack that Melissa Perez made on Jonathan Salinas who was in that window?
Well, I mean, it was very aggressive. It was very dangerous.
Right. And in looking at that as an officer-involved shooting investigator, would you classify that as a homicidal attack that she made on Officer Salinas?
Could be, yes.
And when we say could be, the fact that she is attempting to strike him in the head with a hammer can cause his death.
Correct.
And so how does, for an officer-involved shooting investigator, just now that we talked about the E-tone and everything like that, so how does that change the dynamic of what's going on out there by the time that these three men get there?
Well, it certainly escalated from a felony property crime to now we have an officer that's been assaulted, and it's become very dangerous.
And the candle, you mentioned the candle that was used to strike him. Were you able to view, as it was slowed down, how the mechanics of how she was able to do?
Yeah, she was very accurate, very. It was well done.
May I first motion?
Yes.
I won't be here long. So, when you see in Detective Soto's report that says that he said that these are the reasons he did not believe that it was reasonable for the officers to believe they were in danger, that window blocked by television. In reviewing this evidence, would you agree with Detective Soto that window was meaningfully obstructed by the television that would stop her from her attack?
Stop her attack. I mean, we saw that she went right around it and engaged the officers in the attack.
And what does that tell you as an investigator about her capabilities with the hammer?
That she's very capable.
And what could she do with the hammer if she were so inclined?
She could injure someone, specifically, in this case, the officers, if she wanted to or really tried to.
And based upon your investigation, would that window would that television or the open window have acted as an obstruction to her?
Obviously, it didn't.
So as far as the E-tone in the totality of the circumstances, when Sergeant Flores and Officer Villalobos and Officer Alejandro arrive, should it be considered in the totality of the circumstances that they, as an officer involved shooting investigator, should it be considered in the totality of the circumstances that they are arriving because an officer was attacked?
Of course.
And when we say totality of the circumstances, and you say of course, and it's an obvious thing for you, but tell the jury why it's obvious for you.
Well, you have to consider everything, what they knew, what they didn't know, what knowledge do the officers have available that makes them know whether this is where to kind of file this away as how big a threat she is. He's already attacked someone. You've got to realize that she's capable of it. She's already demonstrated in the totality. You've got to add that this window has already allowed her to attack the officers with no impediment. So you've got to take that into consideration.
So, in following on that, because getting into the mind of an officer or an officer involved shooting investigator, the idea is if that information, you would agree that if that information.
Object to the meeting?
Oh, I haven't finished.
Well, he's saying I'm giving you facts.
I'll give it to you.
That's a leading question.
I wasn't with you. So it's harder for defense attorneys. We're not directors. Okay, so let's go back to because you're talking about the. I think what you said is you got to file it away about how big of a threat she is. Right? Okay, so why does it matter? Why would it matter to Sergeant Flores or to Officer Villalobos or to Officer Alejandro? Why would it matter how big a threat she is?
Well, so so that they can decide how, I guess, defensive they need to approach this situation. Small threat and small opportunity, you can kind of relax a little bit. But if they have an opportunity and they have the means, you've got to really consider that this is a real possibility and that I need to be very cautious.
Right. And so just to kind of compare and contrast it, let's say the bedridden old man had a hammer with him in the bed, right? Would he present the same type of threat as Melissa Perez?
No.
And so would officers respond to him in the same way they responded to Melissa Perez, or in a different way, typically?
Different.
Right. So at the part where we're here, at the second part, we're getting to the third part now, the third scene. They have arrived, and as far as when you're filing away and figuring out how big a threat she is, does that also, for an officer, does that also make them, does it matter, or I guess does it make them need to arrest more? Does it make the need to arrest more important, the bigger the threat?
Well, yes. I mean, if you have someone that's a threat to public safety, you've got to keep the public safe. I mean, that's what the police are in the business of, literally public safety.
And so when we've heard any care or concern for the bedridden man in the apartment, as an officer, as Patrolman Mark Duke, 25 years ago, responding to a situation like that with somebody who is acting the way she is acting, if you found out that there was a bedridden old man, would you have concern?
You've got to, and the actions that we're taking that day were partially in concern for the old man in the house.
And would you need to verbalize it to your fellow officers, or are you trained and are officers trained that in that type of situation, the concern is obvious?
Yeah, I think most reasonable officers that observe that situation and the way she was acting, the set of circumstances, the totality of everything, would know that action had to be taken and that this other person's safety was in danger. You had to consider it. It's reasonable.
As you would agree that officers' communication is officer communication important?
Yes.
And now, sometimes, are there things that officers don't need to communicate about because they already just know what it is based upon their training?
Yes.
Right. So, I guess, and that's what I'm kind of saying about this thing. The type of
Sure.
Now, I want to talk about the, as part of the, as part of the shooting taking place itself, as an officer-involved shooting investigator, what was important to you when you viewed the different body cams and the different angles, when you viewed their actions on that night when Melissa Perez was shot?
Well, I would want to know if their actions were reasonable.
That's right. And so, as you look through these things, did you find examples, as an investigator, did you find examples that would tell you that their actions were reasonable?
Yes, they were trying to talk her out. They were trying to give her every opportunity to end this peacefully. It was reasonable for them to recognize I think it was reasonable for them to have concern about the old man in the other bedroom. So I think, I really feel like all their behavior was reasonable.
And so, in addition to the things you said, tell us about the preference, from your perspective, the preference of going against an unarmed suspect versus an armed suspect.
Well, certainly you would always prefer to engage someone that's unarmed if you can. And that would be your first choice and your priority to do so.
And so, did you note in your investigation and in your review of all these materials, did you note that there were times that Melissa Perez disarmed herself or unarmed herself by putting down the hammer?
Yes.
Were you also able to note, and from seeing the trial, that there were times that officers could see both of her hands and they did not contain a hammer in them?
Yes.
All right. So tell us about your opinion about the reasonableness of trying to engage and make the arrest.
Well, so there comes a point to where you know the arrest is inevitable. It has to be done. The best you can do is to make it is to make that decision at the best possible time to give the officers as much advantage as they can. And if she's laid the hammer down, that would give officers more time than if she had it in her hand. I mean, it's reasonable to believe that it's going to take her time to close the distance to where the hammer is, pick it up, and then focus on the officers.
Right. And as far as we saw, do you agree with Detective Soto that Officer Villalobos had a reasonable belief that the door was unlocked?
Object that it's being in violation of the motion limiting, commenting on the officer's reasonable belief.
Well, I asked if he agreed with Detective Soto, which is in evidence, and he was able to review Detective Soto's
Elicited
testimony.
by them.
All right, so you can rephrase.
So I guess what I'm asking is did you hear Detective Soto testify that he believed Officer Villalobos was reasonable in thinking that the door was unlocked?
Yes.
Okay. Do you share that? Do you share that opinion at least with him?
Yes.
Tell us why.
Well, several reasons. We saw him unlock the door. We saw him communicate to other officers and his sergeant that he had unlocked the door. We see him go on the patio door, believing it could be opened very quickly and easily. I think his actions demonstrated, and I think he verbalized his belief that the door was unlocked.
Now, that brings me to another part of the conversation we had with Detective Soto about what he could see on the body cam versus what the officers were communicating they were seeing on the scene. Can you talk to the jury about, I guess, maybe the perils of just viewing the body cam alone and not taking into account the other information?
Well, your field of view is very limited with the body camera. It only sees what's in front of it, and there's, if you turn your head to the side, a person can see a lot more than the body camera can. And also depth, the depth perception of the camera is further away than they really are. In reality, they're much closer. So depth perception is an issue, and your field of view is an issue with the body camera.
And were you able to see Officer Salinas and Officer Vince Gomez, discussing how close Ms. Perez got to Officer Villalobos with the hammer?
I did.
All right. So now let's kind of, you were talking about how officers communicate things that they're seeing, like Officer Villalobos communicated to a sergeant that the door was unlocked. As an officer-involved shooting investigator, when you have what you can see on the body cam, and you have what Officer Salinas and Officer Gomez are saying that they had just witnessed, which one do you go with?
Well, you would like a first-hand eyewitness account because of the limitations of the body camera.
Right. So because when Detective Soto said if basically it was just whatever he could see on the body cam, is that a smart way to do an officer-involved shooting investigation?
No, you're not factoring in a huge part of the evidence that you have available.
Detective Soto said that he did not follow up with any of these officers or sergeants at the scene, the other sergeants at the scene. Like, what is, in your opinion, is that a smart way to do an officer-involved investigation shoot?
No.
Shooting investigation? Yeah, and so tell us why.
Interviews with witnesses are very, very important. Just to give you an idea, there's only 3 ways to solve a crime: eyewitness testimony, confession, or physical evidence. Those are the only 3 ways. We know that only about 13% of the time do we have physical evidence that leads to solving a case and a conviction in law. 7% of the time, our evidence comes from eyewitness testimony or from a confession, our ability to speak to other people. That was overlooked. And when you don't, you're going to have investigative failures.
What do you mean by investigative failure?
I mean, we're going to have a case that suggests someone is guilty when they're not. You haven't considered all the evidence. You've taken pieces. You've cherry-picked pieces of evidence and chose those that work in the favor of solving this case, but you're not really getting the true facts of the case. You're leaving some out. Police officers are some of the best witnesses we have. Why wouldn't you want to talk to them? Why wouldn't you call them in? You've had 2 years, over 2 years, to talk to them. Why wouldn't you? You know the limitations of the body-worn camera. They're good, but they're not as good as our eyes. And these officers all experienced this firsthand, and they weren't followed up with.
As a homicide investigator, your ability important skill.
It is.
Would you say it's one of the most vital skills, as you quoted those percentages, one of the most vital skills that a homicide investigator has?
If you're going to pick a skill, I would say that is more important than any other one thing, your ability to communicate.
Right. And so the fact that we talked about it, so the fact that Detective Soto didn't follow up, that would be, according to your testimony, that would be a very unusual way to conduct a good officer-involved shooting investigation.
I mean, I guess politely it's lazy, and worst, it's incompetent.
And so as far as and I'll tell you this, they don't deserve to be treated any better than anybody else, but you would agree they don't deserve to be treated worse either.
I think injustice until it's equally applied.
Great.
All right, let's take it's already 12:53. Let's take an hour, 7-minute break and come back no later than 2 o'clock. We'll see you then.
All right,